When task forces drop into public spaces with weapons drawn, who protects the innocent bystanders? We need strict accountability, not retroactive excuses.
Let's be clear. Law enforcement operates under dynamic conditions. The element of surprise is neutralize suspects before they endanger the public or officers.
And the statute relies on objective reasonableness under existing constitutional frameworks. But your point on public friction point, where do you draw the line between tactical necessity and public collateral risk? You draw it where the Constitution intended, at proportionality. A high-risk maneuver in a public venue isn't just a tactical choice, it's a massive hazard. If the execution creates more danger than the warrant resolves, the entire procedure fails its basic test of safety. That's a policy ideal, but on the ground, officers don't get the luxury of a controlled debate when serving felony warrants on dangerous targets. They have seconds to make split-second determinations. Seconds shouldn't cost innocent lives. And urgency doesn't suspend civil rights. If the framework can't protect the public, then the framework needs to be changed. When operations happen in packed public spaces, without body-worn cameras or clear audio tracking, institutional accountability vanishes. We're rarely on unrecorded accounts.
Task force guidelines are under review. Federal operations carry distinct high-threat realities. But evidentiary standards and public transparency are valid concerns.
Which brings us directly to the core legislative gap. Standardizing oversight between local police and federal task forces, ensuring records are maintained from the moment deployment begins. Under Tennessee v. Garner, the Supreme Court established clear boundaries. Deadly force cannot be used unless an officer has probable cause the suspect poses an imminent threat of death or serious physical injury. Executing an unannounced, weapons-drawn raid in a packed public venue deliberately manufactures a high-risk flashpoint, bypassing those protective thresholds.
That misapplies the standard, Mr. Pigram. Graham v. Connor explicitly mandates that the legality of an officer's actions must be judged through the lens of objective reasonableness. From the perspective of a reasonable official on the scene, factoring in split-second decisions under dynamic, dangerous conditions, not with the 20/20 clarity of hindsight.
Both precedents apply, but they clash right at the execution phase. Graham gives latitude for split-second tactical choices during active resistance, but Garner demands that the overall seizure remain proportional. If the tactical plan itself creates an avoidable public catastrophe, does the objective reasonableness test excuse the initial dangerous deployment? Exactly.
Graham evaluates the split-second reaction, but it doesn't give a blank check for reckless pre-planning. If an aggressive public ambush where collateral harm is statistically probable, the state fails the Fourth Amendment balancing test between government interest and individual safety.
You're asking us to rewrite established case law based on procedural theory.